The International Criminal Court is now in session.
Thank you, and welcome to all of the parties today and to everyone who's observing. We're hearing some oral arguments today in the case of Prosecutor versus Lord Blaze. My name is Maria Larry. I'm your presiding judge today. I'm joined by my learned colleagues, Judge Huestis and Judge Zago. Before we get to your oral arguments, which, as you know, you each have 25 minutes with a small allotment for rebuttal. May we start, please, with appearances of the parties, both the prosecution and the defense, for today's hearing.
Good morning. My name is Maria Petrova, and I will be pleading for the prosecution today.
The defense?
Good morning. My name is Daniil Yukorsky, and I will be pleading first for the prosecution, for the defense today. I apologize, alongside my colleague, Ms. Lusted.
Thank you very much. Prosecution, you have the floor.
Madam President, the honorable members of the court, it is a great honor for me to appear before this court. Your honors, today's hearings concerned Mr. Blaze, the man who is responsible not only for failing to exercise his powers properly as the president, but what is more important, for making thousands of peaceful people suffer in the horrible condition of the labor camps, making their lives unbearable and lethal. This case shows that, unfortunately, in the modern world, there are still cruel and, at the same time, indifferent leaders towards their own citizens. However, it is our duty to prevent them from committing such crimes and make sure that they do not remain unpunished. May it please this honorable court. During the following 25 minutes, I will address 4 issues and show that, firstly, the case against Lord Blaze falls within the jurisdiction of the ICC. Secondly, the case is admissible pursuant to Article 17, Clause 1c of the Rome Statute. Thirdly, their case would serve the interest of justice. And fourth, there are reasonable grounds to believe that Lord Blaze is criminally responsible for crime against humanity of enslavement under Article 28, Clause B of the Rome Statute. Your honors, in my first submission, I will prove that the court shall have the jurisdiction over the case, since the temporal and territorial jurisdiction are satisfied, as the crimes that occurred in the territory of Fire Republic were committed after the Fire Republic ratified the Rome Statute. And moreover, the court shall have the subject matter jurisdiction, as all the elements of crime against humanity of enslavement are satisfied. Those are the contextual, the material, and the mental elements. Your honors, firstly, the contextual threshold under Article 7 of the Rome Statute is when committed as a part of a widespread or systematic attack directed against any civilian population. Firstly, since the test of widespread or systematic is disjunctive, the prosecution will mainly focus on the widespread nature of the attack. Your honors, as stated in the Katanga case, the main considerations are the geographical scope of the attack and the number of victims. And in the case of Ruto, Koshei, and Sang, it was found that the attack against nearly 6,000 of people would constitute a widespread attack. And your honors, in the case at hand, it was more than 30,000 of Earthbowers who were exposed to the attack, meaning that it was indeed widespread. Moreover, not only it was the widespread attack, but it was also against the civilian population. In the Kunarach case, the court found that the civilian population must be the primary object of the attack. And in the case at hand, it was the Earthbower men and narrated their killed brothers and sisters, for which they were sent to the labor camps. And as those elements are satisfied, the prosecution submits that the contextual element is met in the case at hand. Your honors, proceeding with the material element. Under Article 7, Clause 2c of the Rome Statute, enslavement means the exercising of any or all of the powers attaching to the rights of ownership, And there is a further explanation, such as imposing on those people the deprivation of liberty. Your Honors, it is also understood that such deprivation of liberty may, in some cases, take the form of forced labor. Therefore, the prosecution will firstly address the issue of powers attaching to the rights of ownership, and then proceed with the forced labor. Your Honors, in the Dominic Ongwen case, the court found several key elements of the powers attaching to the rights of ownership. Those are the restriction of movement, cruel treatment, physical or psychological abuse, the control of the physical environment of the detainees, and forced labor. Your Honors, in the case at hand, Erzbauers were held in the heavily guarded, surveilled fortress that was located on the island. The passports of the detainees were taken on their arrival and never returned to them. Moreover, the Erzbauers were prohibited from speaking their own language and from exercising their own religious rituals, meaning that all those elements are satisfied. And secondly, proceeding with the forced labor. Under Article 2 of the Forced Labor Convention, there are two elements for the labor to be found as the forced. First, the work or service undertaken involuntarily. And second, the threat of penalty. In the case at hand, proceeding with the work or service undertaken involuntarily, as found in the Konodjiraj case, the severely overcrowded condition, the psychological abuse, insufficient food, all this make it impossible for the detainees to consent to work. And in the case at hand, Erzbauers were forced to work more than 12 hours a day with only a 30-minute lunch break, having no weekends at all. Moreover, regarding the threat of penalty, if I may invite the court to the paragraph 12 of the case facts, it is viewed that Erzbauers, if they were simply too weak to work, they were forced to stand in the snow all day, facing the picture of Lord Blaze, being deprived of food and being deprived of water, while the BNS officers watched them suffer. Your Honors, I would also like to invite you to the modern day slavery practice. For instance, in the China, the Uyghurs, a small Muslim ethnic group, it was found that they were exposed to the forced labor, as they could not leave the surveilled detention centers, just as in our case. And moreover, they were forced to undergo the ideological trainings in order to abandon their religion and culture, just as in our case. And since the powers attaching to the rights of ownership were exercised, and the labor was indeed forced in those camps, the prosecution submits that the material element of the crime against humanity of enslavement is also satisfied.
Counsel, can I interrupt you for a second? You just cited two findings in the case of the Uyghurs. Can you tell us where you're citing from those findings?
Your Honors, it was the United Nations human rights experts that delivered their opinion on the forced labor and their concerns. It was the 47th session that took place on the 22nd of June in this year, 2021.
Thank you.
Counsel, one further question on the slavery issue. What weight should the court give to the fact that there was a time limit, a 15-month period for which people were brought to these re-education centers? In other words, it wasn't open-ended, there was a fixed time.
Your Honors, it is true that Ursa Azala promised them that it was not more than 15 months. However, the detainees never knew if it is true and if they will be free to go after those 15 months.
Okay, thank you.
Your Honors, proceeding with the Rome Statute, the person shall be criminally responsible if the mental element is exercised with both intent and knowledge. And in the Kunaraj case, the court found that the required mens rea consists of the intentional exercise of the powers attaching to the rights of ownership. Your Honors, in the case at hand, it was Ursa Azala, the mastermind behind those labor camps. She exactly knew what was going on those camps, about all the atrocities that happened in there. And since the powers attaching to the rights of ownership were exercised with both intent and knowledge, the prosecution submits that the mental element is satisfied. Your Honors, with all the above said, the prosecution is on the position that the court shall have jurisdiction over the case at hand. In our second argument, we will...
Counsel, sorry to interrupt you. Before you move to your second topic, I would like to bring you back to the issue of contextual elements. And I would like in particular to hear the prosecution's argument with respect to the state and organizational policy in furtherance of which the attack was carried out. So can you address very briefly this point and your main arguments?
Yes, Your Honor. The prosecution also submits that it was conducted under the organizational policy. And as stated in the Kenya authorization decision, such criteria, quote, include established hierarchy, means to carry out a widespread attack or systematic attack against the civilian population. In the case at hand, Lord Blaze was the president of Fire Republic, while Ursa Azila, the Ministry of Interior, meaning that there was a clear hierarchy. Moreover, they had those means to carry out a widespread attack. And as proved before, such widespread attack indeed had place in the case at hand, meaning that the case at hand, the attack was conducted under the organizational policy. Your Honor, if I may proceed with the admissibility issue, the prosecution will submit that the case against Lord Blaze concerning crime against humanity of enslavement is admissible pursuant to Article 17, Clause 1c of the Rome Statute, since firstly, the amnesty cannot be invoked before the court. And secondly, the amnesty proceedings that took place in the Fire Republic do not in any way amount to the trial. Firstly, the prosecution claims that the amnesty cannot be invoked before the court, as not only it contradicts the purpose of the Rome Statute, which is to put an end to impunity for the perpetrators of the most serious crimes, but such position was also strongly maintained by the ICC itself, by the European Court of the Human Rights, and by the United Nations. Your Honors, such amnesty was also the blanket amnesty. And as the modern day practice show, those amnesties do not establish peace, but they rather leave the responsible people unpunished and provoke them to continue committing those crimes. As for instance, in Afghanistan, the amnesty law was passed in the 2007, and it became the law in 2009. And as we can see from today's perspective, the conflict has even more intensified. And for now, the Human Rights Watch expressed its concerns about granting amnesty to the Taliban members. That is, the conflict is now intensified, and the people responsible for the grave breaches are still to remain unpunished. Your Honors, moreover, the amnesty proceedings that took place in Fire Republic regarding Lord Blaze's amnesty cannot in any way amount to the trial under Article 20.
Counsel, before we get into the specifics of this, can we go back to the amnesty ban, essentially, is what I'm hearing from the prosecutor's office. How can you reconcile that with the principle of complementarity, that different processes can't suffice? For example, in the present case, as I understand, there were certain conditions for Lord Blaze to not be prosecuted. It wasn't necessarily that he was completely going off scot-free, as it were, but that he had to apologize and make certain manner of reparation in this process. But the policy that you're iterating right now is that there would never be any possibility for a truth and reconciliation process or any kind of amnesty program in lieu of ICC prosecutions. Is that your position?
Your Honor, our position is that the amnesty that took place was blanket. And as stated by the several scholars, the blanket amnesties do in no way bar the jurisdiction of the ICC from proceeding with the case. And it is the situation in the case at hand. It was the blanket amnesty. And Lord Blaze simply satisfied one condition, Moreover, the court that took place was not more than 4 days. And Your Honor, in order to state that it was a trial, in order for the proceedings to be complementary with the ICC, it has to be the trial. And Your Honors, the trial is the examination of evidence, the debate on evidence. However, in the case at hand, as already stated, it was not more than 4 days. And it is clear that in such short term, the court could not have possibly evaluated all the evidence and consider the Lord Blaze's amnesty. Therefore, the prosecution submits that the amnesty that took place was blanket. And moreover, the proceedings that took place could not in any possible way trigger the ne bis in idem principle. Your Honors, in the third question, in the third issue, we will deliver the issue of the interests of justice. The Defense Counsel, in its application, submitted that the case would not serve the interest of justice as it would destabilize the peace process. However, the first thing that we would like to focus our attention on is that, as stated in the Afghanistan case, it is the prosecutor himself who shall decide whether the case would or would not serve the interest of justice. And moreover, under Article 53 of the Rome Statute, the court may review the prosecution's decision only if the prosecutor decided not to proceed with the case. However, it is not the situation in the case at hand. In the case of Lord Blaze, the investigation stage has already passed, and the prosecutor did not find any grounds to state that the case would not serve the interest of justice, meaning that the application of the Defense Counsel has no place to be raised on the current stage. Your Honors, moreover, the Defense Counsel submitted that it would destabilize the peace process. However, we want to focus our attention on the fact that the peace has already been established in the Fire Republic. The peace agreement was already signed, and no casualties were reported after the Erzbauers referred the case to the ICC, meaning that the very interest of justice in this case is to ensure that those responsible for the crimes do not remain unpunished, and that the Erzbauers are no longer afraid of continuing to living on their country. Your Honors, the prosecution would like to close its submission of the admissibility and interest of justice with the quote of Under-Secretary General for Legal Affairs and the United Nations Legal Council. Justice should never be sacrificed by granting amnesty in ending conflicts. Your Honors, the last issue concerns the responsibility of Lord Blaze. And with this respect, the prosecution submits that there are reasonable grounds to believe that Lord Blaze is criminally responsible for crime against humanity of enslavement under Article 28, Clause B of the Rome Statute. Your Honors, under the said article, the person shall be criminally responsible if he holds superior subordinate relationship with the person who committed the crime. And it is established by the effective authority and control. Moreover, it must be due to the failure of the superior to exercise his control properly over the subordinate. Your Honors, in the case at hand, the prosecution submits that there are reasonable grounds to believe that Lord Blaze is criminally responsible for the crime of enslavement under the said article, since firstly, there were superior subordinate relationship. Secondly, Lord Blaze knew about the atrocities that took place in those camps. Thirdly, those crimes were within his effective responsibility and control. And fourth, he failed to take all necessary measures as the President of Fire Republic, as the superior under Article 28, Clause B of the Rome Statute. Your Honors, firstly, the superior subordinate relationship indeed existed between Mr. Blaze and Ms. Azila, since he exercised both effective authority and control over her. Your Honors, as stated in the Bamba case, the authority is the right to give orders and enforce their obedience, while the control referred to the superior's material ability to prevent, repress, or further to submit the crimes. Moreover, Your Honors, the presidents are commonly considered as those they had significant authority in the national security of the country. And if I may invite the court to the paragraph 17 of the case facts, it is viewed that Lord Blaise was the one who requested to start the peace negotiations in April 2019, which shows the authority. Later, in the Exhibit 1, line 7 to 10, it is seen that Ursa Ezaela acted in accordance with Lord Blaise's orders, as she agreed to fulfill his command regarding the sending of the detainees. In the Exhibit 2, we can see that the office of the president authorized the sending of such materials, meaning that the control indeed existed, and the superior subordinate relationship were present between Lord Blaise and Ursa Ezaela. Your Honor, secondly, Lord Blaise had knowledge of the crimes that were committed. As stated in the Delalic case, such knowledge can be established by the circumstantial evidence that include the superior's official position and means of communication. In the case at hand, Lord Blaise said in the Exhibit 1 that you are opening yourself to a mutiny, line 7. Later, he says, send 10,000 of detainees to the center. Moreover, in the line 11, we can see that Lord Blaise knew that the detainees were working. And with respect to that, the prosecution would like to invite you to the case of the Blaskic. In this case, the accused himself declared that he ordered the release of the detainees. And the court found that regarding that he had powers in this area, he could find out about the conditions in which and the circumstances in which the detainees were held, just as in the case at hand, where Lord Blaise himself ordered the release of the detainees, meaning that he indeed had knowledge. Your Honors, thirdly, the crime of enslavement that took place in Center Rik was within his effective responsibility and control.
Before we get on to his effective control aspect of it, I want to go back to the mens rea here a little bit. Isn't it possible that he didn't necessarily know that there was a crime going on? Did he need to know that there was a crime occurring for him to be responsible and to possess the requisite mens rea for this crime?
No, Your Honor. He only had to know some of the details or some of the information with respect to the atrocities that took place in the labor camps. And with respect to the exhibits that the prosecution relies on, we can see that he could have had, and he indeed had, some knowledge of the atrocities that took place and about the crime that Ursa Ezaela committed, meaning that.
Can you point me to your specific references as to where he should have had knowledge of the specific crimes were being committed?
Your Honors, firstly, from line 11 of the Exhibit 1, we can see that Ursa Ezaela says that the detainees are working, meaning that Lord Blaise knew that the forced labor took place in those camps. Also, he ordered the release of the detainees. And again, with respect to the Blaskic, it shows that he indeed could have known about the conditions in which the Erzbauers were held. And also, Your Honors, in the paragraph 7 of the case facts, we can see that Ursa Ezaela was obliged to report to him about all that happened in those camps. And later, in the line 10 of the Exhibit 1, it is confirmed, as Ursa Ezaela says, I will send you my first report about the center, meaning that he indeed had knowledge of the atrocities that took place in those labor camps. Your Honor, proceeding with the third element is that it was indeed within his effective responsibility and control. Once again, the prosecution wants to focus your attention on the fact that Ursa Ezaela reported to Lord Blaise. And fourth, Lord Blaise failed to take all necessary measures within his powers, as he did not prevent the commission of those crimes. He also did not repress those crimes, as he did not stop the ongoing crimes, and he did not punish Ursa Azayla accordingly. And later, when those crimes occurred, he did not submit it to the competent authorities, meaning that he failed to take all necessary measures that were within his power. Your Honors, with all the above said, the prosecution submits that there are reasonable grounds to believe that Lord Blaze is criminally responsible for crime against humanity of enslavement under Article 28, Clause B of the Rome Statute. Your Honors, if there are no further questions, I would like now to close my pleading and thank you for your attention. May it please this honorable court.
Thank you, counsel. Defense, your arguments?
Madam President, and may it please the court, my name is Neil Ukorski, and I appear on behalf of Lord Blaze, the defendant, alongside my learned co-counsel, Miss Lusted. Today, I will be addressing two questions before the chamber. First, whether this case falls within the jurisdiction of the court, and second, whether the case is admissible in light of the principle of ne bis in idem. Starting then with the question of jurisdiction, specifically jurisdiction retenere materiae, the defense submits that neither the contextual nor the specific elements of the crime against humanity are fulfilled. The contextual elements were helpfully recalled by the prosecution, and to establish jurisdiction, there must be reasonable basis to believe that all of the elements are present. I will focus on only one today, the policy requirement that was helpfully highlighted by Judge Zago. In the case at hand, there is no basis to believe that the alleged crimes committed at Center Rig were pursuant to a state policy to commit such an attack. The state policy requirement exists to distinguish acts that are, quote, spontaneous or isolated acts of violence from crimes against humanity, to quote the Ruto trial chamber. And indeed, in Ruto, a general policy was not enough. The court focused on the involvement of the defendant in creating the policy. And it was recalled in the trial chamber in Katanga that this must not be conflated with the widespread or systematic requirement. What we have here in this case is a lawful program of internment in a situation of non-international armed conflict. As paragraph 8 of the facts makes clear, those placed in education centers were terrorists. In fact, the Fire Republic may have positive duties to protect its peaceful citizens from terrorist attacks. Any alleged acts that went beyond the lawful program of internment are spontaneous and isolated in the sense that they could only be perpetrated by lone actors operating outside of their instructions. Turning to the specific elements of the crime against humanity of enslavement, the paradigm physical element is chattel slavery, or to quote the elements of crimes, exercising all of the powers attaching to the right of ownership. Deprivation of liberty, as was stated by the prosecution on its own, is not sufficient unless combined with additional factors such as forced labor or coercion. First, all labor undertaken by the prisoners was voluntary, in direct opposition to the chattel slavery paradigm. Voluntary labor is a legal and widespread practice within the penal system and is recognized by the ILO Forced Labor Convention. And indeed, we can quote paragraph 2C, any work or service exacted from any person as a consequence of a conviction in a court of law is not considered a form of forced labor. This also applies to situations of internment in non-international armed conflict. In the case at hand, the labor served a key educational process within a broader transitional justice process. Second, the evidence raised in support of any forced labor or coercion is unreliable and insufficient. What the prosecution has stated as fact is a series of unsubstantiated claims. The only witness making such allegations is Mr. Harry Rock, a leader of the Association for an Autonomous National Government, a terrorist organization that has taken violent action against the Fire Republic. As such, it is only natural for him to seek to discredit Lord Blaze and the peace process. Furthermore, Mr. Rock's testimony is hearsay. It is relayed in the form of an interview conducted by journalists for human rights. The Katanga trial chamber recalled that the probative value of such evidence must be analyzed with respect to its consistency with the evidence as a whole. His claim that there were no visible signs of branding at Center Rig is directly contradicted by aerial footage which shows a truck bearing the Snowflake automobile logo. The only other evidence allegedly from the family members of detainees is anonymous hearsay. Indeed, their only contention is that they were not informed of the length or reasons for their detention and that their passports were confiscated. In Lubanga, the trial chamber held that such evidence ought to only be used to corroborate other evidence, and yet, on these points, it stands alone. Even if their reports happen to be correct, they do not mention any forced labor or coercion that could bring the alleged acts remotely close to the paradigm of chattel slavery. The mental element of the crime against humanity of enslavement is knowledge or intention. Lord Blaze's sole instruction to Miss Azilla was to use, quote, necessary means. There is no indication that he intended anything beyond legally detaining terrorists that posed a threat to national security. Moreover, there is no indication that Lord Blaze had any knowledge of the alleged crime. Exhibit 1 demonstrates that Lord Blaze knew about the detention of terrorists, and crucially, that he ordered the release of thousands of prisoners from another re-education center. Your Honors, that is hardly the act of a would-be enslaver. Exhibit 2 provides scant information beyond what is written in the document, materials that can be used in the maintenance of a detention center and in the voluntary labor conducted therein were provided. Indeed, nothing suggests that Lord Blaze had any knowledge of the allegedly forced nature of the labor or any possible coercion. Lord Blaze knew only what he was told, that there was an educational program being conducted at Center Rig. He testified in amnesty proceedings that he had no knowledge of the, quote, atrocities committed by Ursa Azilla.
Counsel, one moment. I want to make sure I'm following your argument. It seems to me the setup to this argument was that these civilian detainees are somehow roughly equivalent to prisoners and or military detainees with regard to being able to use their labor. Am I following that correctly?
That is an element of the argument. It is not our contention that they are military detainees. They are civilian detainees, in fact, but it is a lawful program of internment in non-international armed conflict. As such, they can be lawfully detained without a trial.
But then you make the next jump to now their labor can be, I guess, voluntarily extracted, I guess would be.
Well, I mean, the crucial submission by the defense is that there's simply no evidence of any forced labor. What we are told, it is the word of Ursa Azilla against the word of a terrorist. And of course, we accept that accepting the word of the person who is alleged to have committed the crimes at face value is not enough to substantiate our case. But it is also our contention that it is not enough for the defense to hang their entire case on the testimony of a person who has committed direct violent action against the state and has very good reasons to discredit the entire peace process.
Okay.
And indeed, the burden rests with the office of the prosecutor to demonstrate that there is reasonable basis to believe that the crime against humanity of enslavement was committed. The evidence presented here is the hearsay of a rebel, anonymous hearsay, and 2 entirely circumstantial documents. And we acknowledge that reasonable basis to believe is not an incredibly high bar to meet. And yet the evidence is far below what has been required by the pretrial chamber in the past. And as such, we submit that the court does not have jurisdiction in the case at hand.
All right, yeah, thank you. I appreciate the clarification.
This brings me to the second ground that I'm addressing, which is the question of admissibility. Madam President, you very helpfully recalled that the jurisdiction of this court is complementary to national jurisdictions, and the Office of the Prosecutor has noted in the policy paper that the court's role is to step in only when there's, quote, a clear failure to act by states concerned. The principle of ne bis in idem embodies complementarity as it ensures that the same person is not punished for the same conduct twice. Your Honors, there has been no failure to act by the Fire Nation. There is no duty to prosecute crimes against humanity, unlike the duty under the Geneva Conventions, for instance, to prosecute grave breaches. Moreover, no jurisdiction recognizes a right to see the perpetrator of a crime be punished. Our central contention with respect to ne bis in idem is that the amnesty proceedings do constitute a trial for the purposes of Article 20, Section 3. Starting with the text of the statute, unlike Articles 20, subsection 1 and 2, which explicitly reference the accused being convicted or acquitted, Article 20, Section 3 is drafted as a broader provision that goes beyond a full determination on merits, including any form of judicial consideration that constitutes being tried. Given the recognition of the principle as a norm of natural justice under Article 9 of the ICCPR, it ought to be construed broadly, as the defendant's right to a fair trial is directly engaged. Indeed, the amnesty proceedings in question were a trial for the purposes of Article Section 3. First, the amnesty granted to Lord Blaze was the result of a judicial decision acting under authority conferred directly by statute. Second, the judicial ruling is final. Third, the Truth and Reconciliation Commission did consider the merits of whether crimes were committed and found that some Fire Republic officials committed crimes during the conflict. Turning now briefly to the question of travaux preparatoires, the existence of the so-called amnesty exception has not been settled. According to Philippe Kirsch, the chairman of the Rome Diplomatic Conference, the provisions were left open to reflect, quote, constructive ambiguity. The consent of certain state parties, for instance, South Africa and Colombia, is dependent on this ambiguity, and thus, once again, Article Section 3 cannot be construed narrowly. Crucially, while the question of the amnesty exception may have been settled elsewhere, it has not been settled by this court. Precluding even the highly judicialized amnesty proceedings, such as those in this case at hand, would jeopardize the operation of transitional justice processes worldwide. Notably, in South Africa, conduct that would have qualified under the crime against humanity of apartheid was part of the amnesty process. This court must be wary of doing more harm than good by undermining such processes. Moreover, the amnesty proceedings were in no way for the purposes of shielding Lord Blaze from responsibility, nor otherwise lacking in independence or impartiality. First, on the question of shielding, it has been noted by scholars that a particularly high threshold must be demonstrated by the prosecution. Louise Arbour has noted that should be devious intent on the part of the state. The amnesty proceedings in question are a central part of transitional justice, and there's nothing to suggest any such devious intent. The fact that Lord Blaze sought amnesty to protect himself against any criminal prosecution is simply a tautology. Avoidance of criminal liability and a focus on peace and reconciliation is the purpose of all amnesty proceedings. Second, on the question of impartiality, there's simply, once again, no evidence that there was a flaw within the procedure of the amnesty proceedings. It was chaired by a member of the Fire Republic Judiciary and places reliance on the report of the Truth and Reconciliation Commission. Madam President, Your Honors, we are acutely aware of the limited resources of this court. Indeed, the pre-trial proceedings are designed to distinguish cases that are meaningfully engaging with the object and purposes of international criminal justice and those that are not. This case is an example of the latter. There is no reasonable basis to believe that the contextual or specific elements of the crimes against humanity and enslavement are present in this case. Moreover, Lord Blaze has already...
Can I stop you there? Should the chamber, are you asking this bench to be considering the resources of the court and whether or not this case should proceed?
It is not a central part of our submissions, Madam President, but it is difficult for the defense to not note that there is, as we have stated at multiple points, a distinct lack of any convincing evidence. Yet there are cases all across the world of grave breaches of the statute of the ICC that are not being investigated and are not coming to this chamber. And indeed, resources must always be considered by courts when taking into account whether or not a prosecution should go forward, especially when there is such a distinct lack of evidence.
Is that a consideration for this bench, or is that a consideration for the prosecutor?
That is certainly a consideration that the prosecution, that the office of the prosecutor should be taking into account. But I believe that there is nothing that stops the bench from taking this into account as well, especially at the pre-trial stage, when what we're trying to determine is whether or not there's a case at all to go forward.
Thank you. You can proceed.
Thank you. In fact, Madam President, this concludes my submissions. Thank you.
Madam President, Your Honours, may it please the Court, my name is Madeline Lusted. My learned co-counsel, Mr. Okorski, has already addressed the first two questions before the Chamber. I thus argue to proceed directly to the final two questions, which are, firstly, whether the prosecution is in the interest of justice, and secondly, whether Lord Blaze is criminally responsible under Article 28B of the Rome Statute. Your Honours, to start with the question of interest of justice, the defence's submissions are twofold, and I would like to bring to Your Honours' attention a number of policy considerations alongside the relevant provisions, an angle that has been somewhat neglected in the prosecution submissions, we note. First of all, the prosecutor may investigate the decision to proceed. With respect, the prosecution has somewhat misconstrued our argument. We have never submitted, nor do we propose to, that it is not within the prosecutor's discretion to decide the prosecution is in the interest of justice. We are merely pointing out the logical corollary that if such a ruling is within the margin of discretion, it must also be within the prosecutor's discretion to decide it is not in the interest of justice. I will touch again on the effects of the Afghanistan case in a moment, but we submit that the effect of this case cannot be to hamstring the prosecutor towards a presumption of the case being within the interest of justice. And this is really our central contention. The prosecutor can and should review whether a case would be against the interest of justice under Article 53 of the Rome Statute. The text of the statute helps us in determining what this really means. If we turn to the preamble, the statute shows commitment to the aims of justice and upholding international peace and security, and I refer to paragraphs 3 to 5 and 10. With judicial oversight of decisions to proceed with the prosecution, the object and purpose of the statute cannot be achieved without judicial oversight. I apologize. Thus, what we are really submitting is that our construction of the power to review under Article 53 must accord with the object and purpose of the statute as a whole, according to the accepted rules of treaty interpretation. And I refer Your Honours to Article 31 of the VCLT 1969. Interest of justice must thus have a meaning compatible with the maintenance of international peace and security mentioned in the preamble. This hardly commits the prosecutor to the outcome the prosecution argues for. To turn to my second element of my first submission, Lord Blaze's prosecution is not in the interest of justice. Article 53(2)(c) directs the prosecutor to factors to be considered when considering the interest of justice question. The defence submits that the prosecutor's margin of discretion is permitted to consider matters of peace and security, as well as alternative justice mechanisms. Your Honours, we must cleave to the wording of Article 53(2)(c) itself. It directs the prosecutor to take into account, and I quote, all the circumstances including, end quote, indicating that the list of factors is illustrative and not exhaustive. The notion of interest of justice must therefore be wider than merely the gravity of the crime, the interest of the victims, the age and infirmity of the accused, and his or her role in the alleged crime. Our central contention is that a destabilization of the peace process is a permissible consideration under this article. It is true that the Office of the Prosecutor's 2007 policy paper is sometimes cited as evidence to the contrary. Respectfully, however, Your Honours, the situation the world finds itself in has changed since 2007. On the 16th of June this year, a new prosecutor, Mr. Karim Khan, was appointed as prosecutor. He has previously worked as a special advisor in assisting the Iraqi government in holding ISIS terrorists accountable for crimes against humanity, and therefore has direct experience with the sort of armed conflicts, non-international armed conflicts we are dealing with. Since that date, there have also been multiple conflicts throughout the world: Myanmar, Iraq, Afghanistan, Ukraine, and the emergence of ISIS in the Levant. The prosecution refers to this peace process as I quote, as established. But with respect, this does not seem to take into account the delicate nature of such conflicts. In several of the above conflicts I mentioned, violence actually re-emerged after a breakdown of faith in the subsequent peace proceedings. Rebuilding a stable state must be part of the peace process and subsequent procedure of justice. I would also like to highlight the fact that there is good reason to distinguish the Afghanistan case, which the prosecution cited. Such a consideration, that is the peace process, to quote directly from the case, cannot be disqualified for being, quote, predictably inconclusive, i.e. it is a political question and not a legal question. But it is not a political question. It is a question of fact, of the same nature as interests of victims, and one that pertains directly to this court's jurisdiction. I would also like to highlight the fact that the peace process underway in Black Mound is extremely delicate. Although a peace agreement has been signed, an integral element of the agreement was the subsequent adoption of amnesty law, which Lord Blaise was given amnesty on the 23rd of August 2019. Your Honours, the Thai Republic is a sovereign nation undergoing a process of transitional justice. To undermine its decision not only threatens to incite illegal reprisals against former members of his regime, but also undermines the Republic's attempt to forge its own vision of its own future. Finally, I would also highlight the fact that Article 53(2)(c) refers to the role of the accused in the alleged crime. As my learned co-counsel has stated, labour camps are not per se illegal under the Forced Labour Convention, which the prosecution directed us to. With respect, I would also reiterate my learned co-counsel's point that this court is of limited time and resources. It is designed to deal with the worst crimes against humanity. This is a case where forced labour cannot be established, enslavement cannot be established, and as I will highlight in a moment, criminal responsibility also cannot be established. This court cannot be afforded to be undiscerning in the face of such an absence of evidence. Unless I can assist the chamber further, I can conclude my submissions on this point. On the second ground, the defence submits that there are no reasonable grounds to believe that Lord Blaise is criminally responsible for crimes against humanity of enslavement under Article 28b. Prosecution somewhat neglected to mention the mental element required by Article 28b, which is recklessness rather than omission liability, as Shabas notes. Your Honours touched briefly on this point. This would require Lord Blaise to have known or consciously disregard information which clearly indicated the BNS were committing the crime of enslavement, and no such knowledge or disregard can be imputed on the facts. The prosecution has relied heavily on the testimony of Hararu Rock. I propose to demonstrate why this evidence is untenable, as my learned co-counsel has already attempted to do. The only item of evidence that has any bearing on Lord Blaise's state of mind is Exhibit 1. The evidence raised to his knowledge, whether implicit or explicit, of the alleged crime is unreliable and cannot be used without imparting an intention to Lord Blaise that simply cannot be construed from the conversation we are given a transcript of. My learned co-counsel has already defined the meaning of knowledge. The conversation is patchy and is interrupted by technological interruptions, and I quote directly, "The connection is not very good here," end quote, meaning that Lord Blaise received only nuggets of information. Mr. Zila was a high-ranking member of his regime, and he had no reason to assume, in the absence of evidence, that enslavement was or would take place. We also submit that Lord Blaise was not exercising effective control at the time of the alleged offences.
Counsel, can I stop you before you get on to effective control and going back again to this mens rea element? Did he not have a responsibility after issuing an order that by any means, that Ms. Ursa should take care of this, that he should follow up, even if the connection's bad? Should he not call back or ask for interim reporting? Does he not have some sort of responsibility in the absence of the information he received?
With respect, Madam President, yes, he may have that responsibility. We do not contend that. We do, however, submit, as I will go on to say, that even if that responsibility exists, there was no possible way for him to deliver that follow-up or to inquire about the conditions in the camp because of the technological interruptions at that time. It was simply not possible for him to do so. And the accused cannot be held to account for something that was not simply not possible. If I may briefly conclude, the prosecution conceded this point somewhat when they acknowledged Mr. Zila as I quote, the mastermind of the camps. They did not claim the accused was the mastermind. In Halilovic, the majority required effective control only at the time of the commission of the crime. This was confirmed by the ICTY in Orich and in Bemba. As such, the defence submits that Lord Blaze's criminal responsibility for the alleged acts cannot respectfully be established under Article 28. Unless I can assist the court further, that concludes the defence's submissions.
Thank you, counsel. Back to the prosecution. Is there any rebuttal?
Yes, Your Honors. Your Honors, the prosecution will raise 3 issues on the rebuttals. First, concerning the admissibility of evidence. Secondly, the admissibility of case due to the shielding of Lord Blaze. And thirdly, concerning the transitional justice, namely that Truth and Reconciliation Commission failed to exercise its duty, which is to establish the truth. Your Honors, firstly, proceeding with the admissibility of evidence, the defense counsel kept stating that the evidence is inadmissible. However, with respect to that, we would like to focus your attention that in the Article 61, Clause 5 of the Rome Statute, it is stated that, quote, the prosecutor may rely on documentary or summary evidence and need not call the witnesses expected to testify at the trial. Moreover, the Trifter stated that, quote, most of the evidence submitted by the prosecutor at this stage of the proceeding is documentary in nature. Those are also statements of witnesses, reports of the NGO or international organizations, press articles, audio or video materials, etc. Moreover, in the case of Fruto, Cochet and Sank, the court found that the NGO evidence is indeed admissible. And secondly, Your Honors, in the Ongwen case, it was found that it must be established whether the evidence is mutually corroborative and corroborative of other prosecution's evidence. Your Honors, in the case at hand, the evidence presented, those are the NGO aerial footage, Harorok's interviews, exhibits, etc. All these are consistent with each other, and it is consistent with the information provided by the case, meaning that it is indeed mutually corroborative, and the probative value of the evidence is satisfied. So the admissibility, though the evidence is admissible before this court. Our second point concerns the shielding of Lord Blaze. Your Honors, the defense counsel submitted that there was no shielding. However, we would like to focus your attention on the fact that in the Gaddafi case, the court found that shielding is possible in case of sham proceedings, the indicators of which are disregarding relevant facts or terminating the investigation. Your Honors, in the case of Trent, national authorities did not take all necessary and reasonable steps to secure the evidence. Those are Exhibits 1, Exhibits 2, the statements of witnesses, meaning that national authorities indeed shielded Lord Blaze, and the case is still admissible. Your Honors, moreover, such amnesty was once again not only blanket, but it also was the self-amnesty, as the Fire Republic officials were the one who passed this law, and it was the Fire Republic's parliament who adopted the law number 14, under which Lord Blaze sought amnesty and was granted it. Your Honors, moreover, it was only one condition that Lord Blaze simply satisfied, and therefore it cannot be viewed as the conditional amnesty. So therefore, with respect to that, the prosecution submits that the case is still admissible. Your Honors, thirdly, the defense counsel submitted that, and he kept referring to the transitional justice. And with respect to that, we would like to turn to the transitional justice and its role on this case. As stated by the International Center for the Transitional Justice, quote, it is a response to systematic or widespread violations of human rights, and it seeks recognition for victims and promotion of possibilities for peace, reconciliation, and democracy, meaning that one of the transitional justice are truth commissions. and they have the primary purpose of investigating and reporting on key periods of the recent abuse. However, Your Honors, in the case at hand, such Truth and Reconciliation Commission was created and even appointed by Lord Blaze himself, as stated in the clarification 5. However, their goal was to ensure the establishment of the truth, but they omitted what crimes were committed. And moreover, they did not name any perpetrators by name, meaning that it failed to ensure the establishment of the truth since the investigation that took place were ineffective. And since it did not achieve its main goal, which is inter alia to satisfy the victim's interests, the case would still serve the interests of justice. Your Honors, with all the above said, the prosecution still maintains its position and asks to decide in favor of the prosecution. May it please this honorable court.
Thank you. Defense, any rejoinder?
Yes, thank you, Madam President. And just to clarify, and I apologize to the defense, to the prosecution counsel if there was any confusion, it was not our central contention that the evidence was wholesale inadmissible, but rather it was insufficient. On the point of hearsay and anonymous hearsay, however, there are admissibility issues, and I thank the prosecution for mentioning the question of aerial footage. If I may read directly from the case facts, at paragraph 12, Harry Rock's testimony states that he was unable to identify the company that they were allegedly working for, as there were no visible signs or branding at the workplace. Aerial footage, on the contrary, at paragraph 14, shows a truck within the facility with the logo of Snowflake Automobile, one of the biggest automobile companies within the Water Kingdom, again, to quote directly from the case facts. Your Honors, this is the question of mutually corroborative evidence, and what we see here is that, contrary to the rebuttal of the prosecution, it is not only insufficient, as I submitted before, but it cannot be admissible because it is not mutually corroborative. And the second point I would like to make in rebuttal is on the question of, quote, sham proceedings, as mentioned by the prosecution in their citation of the Gaddafi case. This is a significant allegation to make, and one that we submit is not substantiated by any evidence. Indeed, what we have is the, as I stated previously, a member of the judiciary who is exercising statutory power. There is no evidence of any flaw within the procedure that the prosecution has been able to point to on the point of admissibility. This concludes my submissions in Sir Rebuttal, and I'd like to pass on to my learned colleague.
Thank you to my co-counsel for highlighting those very important points. I would only briefly like to add very quickly in response to the evidentiary point and in regard to the mental element point. I would like to direct the court to paragraph 23 of the case facts. The prosecution has relied very heavily on the testimony of Harari Rock, but has seemingly neglected the testimony of the accused himself. It states, he explained that he only knew about the educational program as reported by Sir Azila, i.e. he received follow-up reports, and there was no reason for him to doubt the contents of those reports. We would just like to bring that to the court's attention because it rather hits directly at the prosecution's contention that the accused knew about the conditions in the camps.
Does that conclude your arguments, defense?
Yes, thank you.
Thank you very much. Well, that concludes our hearing then today. Thank you very much for all of your submissions. The judges will now adjourn and go to the deliberation room where we will take some decisions. We'll return back very shortly. Thank you.
So I will now send the judges to the deliberation room and the teams to separate breakout rooms. The judges will be here soon.
Okay, and we are back. I first of all just want to thank everyone again today for putting in the hard work and for coming here prepared and ready in mind and spirit to give these arguments again. We really appreciated the diligence, and when I say we have one judge here, the other one maybe has gone a little bit missing, but we're hoping to get back. Let's see, Judge Zago. But we really want to thank you for all of the time and effort that you put into this. At this stage, it is my responsibility, I believe, to announce the winning team, though we have to say that we had a long discussion about all of the positives that came out of both. But at this time, somebody stop me if I'm not supposed to be announcing this. At this time, the winning team is going to be N25, the prosecution. And I have a note that says that Judge Zago has problems, but we can continue. Hopefully she comes back in. Congratulations, but congratulations to all of you. And I think we have some comments that we just want to go, maybe Judge Huestis, I think we can see what your thoughts were on some of this.
Yes, thank you. So yeah, to all three of the council, your preparation was evident. All three of you communicated really well over this format. Your pace was good. Your composure and response to questions was good. So very, very strong performance by all three council. But I want to offer some constructive criticism. We're not allowed to spill the beans on the case facts or answers. So I'm focusing primarily on advocacy. And before I start, I want to expose my bias. Through most of my career, I was a trial attorney, and I come from a common law background. So I'm very used to storytelling in the courtroom, and I want to have facts in front of the law. So that's my bias. And that might fit your practice in your home jurisdiction. It might not. If it doesn't fit your practice, then just ignore what I'm saying. But if it does fit your practice, or if something I say sparks an interest, well then take it to heart. I'm just offering it in the spirit of constructive criticism. So Maria, with the prosecution, I'm just running down my notes, so it's just in the order of it just happening in the hearing. But Maria, I really appreciated the fact that you started your presentation with a little bit of a story. And the reason that that's so important to me is I understood the theory of your case right from the beginning. And then as you made each of your follow-on points, I knew how it fit into your theory of the case. So I appreciated that very much. And it made it very easy for me on the bench to follow your arguments and follow where you were going right from the beginning. Your responses to questions were outstanding. Your composure was outstanding. Yeah, really, I don't have anything more to offer. I have many more notes, but they all go into specific arguments. But really a good job of providing a lot of structure and making your argument very easy to follow. The defense, Danielle, you have really good presence. You started out very strong. You didn't give me any facts at the beginning, so I didn't know your theory of the case. So it left me to kind of fill in the blanks as you went through your specific arguments on jurisdiction and admissibility. And it made it harder for me to follow what was going. So what would have really helped me specifically, if you would have said from the beginning why you thought Lord Blaze was doing a great job as the head of state, and the things he did properly, and maybe where the prosecution was erring or possibly overreaching in their theory of the case. But you didn't do it explicitly, so you kind of left it to me to add up in my head, and it made it more difficult for me to follow the arguments. But you did show really, really good composure in responding to questions from the bench. You did step on one landmine. The quote was, "We are acutely aware of the limited resources of the court." You have to expect questions and follow-up questions there, and you got them. So just be aware, you know, in your future practice of law down the road of attacking the decision maker, if you will, because you got the response that's to be expected when you do that. Madeline, I really liked your demeanor. I liked how you came across. It was more conversational than the other two counsel, and I sense that probably fits your personality. So keep running with that. I keep beating on the same thing, but I didn't get any sort of story up front. So you had to just jump into your two arguments for interests of justice and criminal responsibility. For the defense, the two counsel, the arguments started to blend and bleed across. So there wasn't the same structure that the prosecution had. You circled back to your counsel's point about the court's limited resources. I would hope you wouldn't stick to your notes and plow through into that, but maybe, you know, listen and pay attention to what happened to your co-counsel and avoid that landmine. But you stepped on it and moved forward, so that was good. And then you looped back to Lord Blaze's mens rea. And when you did that, you referred to the earlier question and answer between counsel and the bench. That was very good. That was very good. Both rebuttals were strong, but I want to finish on a very high note. Maria, I thought your rebuttal was particularly outstanding. You showed more conviction in your rebuttal than you did in your case in chief, which I liked. And I thought you were organized. It was limited to just the 3 issues, and it was strong. So it was a very good rebuttal. So do any of you have any questions for me?
Just
All right.
many thanks.
Yeah, well, once again, congratulations. All 3 counsel did an outstanding job. So congratulations.
Thank you.
Thank you again.
Well, thanks from all of the bench then. Those comments were fantastic. Thank you, Judge Huestis. So I would just adopt them on behalf of the whole bench. I couldn't say anything more than just good luck in all of future rounds, all of the future cases, all of your future careers. And taking from this is and learning and going forward. I'm really looking forward to seeing you again in the future. But in the meantime, we'll have to adjourn today's hearing. Thank you very much.
Thank you, Madam President. Your Honor, thank you.
Thank you.